Hello, everyone, and welcome to this webinar hosted by Security Compass. My name is Eleanor Lee, Product Marketing Manager at Security Compass, and your host for today's webinar. Before we get started, I'd like to address a couple of housekeeping items. First, a recording of this webinar will be available after today's event. You will receive an email with a link to the recording. Second, we encourage everyone to raise questions. Please submit your questions into the chat and we'll collect and address them at the end of the presentation. We'll also open up the audio lines at the end of the presentation for questions. We hold webinars that deep dive into a range of cybersecurity, privacy, compliance, and software risk topics every month. If you have attended any of our past webinars, we're happy to welcome you back. For those of you who may not be aware of us until today, Security Compass started out with a team of very experienced penetration testers in 2004 and has since evolved to become a security software company that offers professional advisory services, training, and SD elements, a first of its kind expert platform that translates security standards into actionable tasks to improve your security posture. Our mission is to help customers manage cybersecurity risk without slowing down their business. For today's webinar, we're going to take a close look at the global impacts of the General Data Protection Regulation, or GDPR. I'm very pleased to have here with me Judy Zhu, a member of our research team here at Security Compass, specializing in privacy, risk, and compliance. Judy is an experienced security consultant and researcher, having implemented privacy programs, compliance initiatives, and led security assessments across a variety of Canadian and international businesses. Judy is a certified information privacy professional. Judy, thank you so much for joining me here today.
All right, thank you for the lovely introduction, Eleanor, and I'll start by introducing our agenda today. Actually, I'll start by saying happy International Data Privacy Day to everyone, which is today. So hopefully we have a relevant topic that'll give you some more insights into data privacy trends and GDPR compliance practices. So our agenda for today includes the origins and goals of the GDPR, the essential elements such as control, transparency, data protection, some key steps towards GDPR compliance, the current state of the compliance with the GDPR, what are the trends, and is GDPR enforcement working? We'll look at some global impacts and some other privacy regulations that have been inspired by the GDPR, including the California Consumer Privacy Act, the CCPA, and the upcoming EU ePrivacy regulation. We'll take some questions at the end. So diving into the origins and goals of the GDPR is a comprehensive data protection and privacy law that applies to organizations that collect, use, or share the personal data of EU residents. So in this webinar, we'll explore the essential elements and discuss what GDPR compliance looks like. Starting with the origins of privacy and data protection. So privacy and data protection are two concepts that are enshrined as fundamental rights in the EU treaties and charter. So in the EU, there is this notion of the right to private life, to be autonomous and in control of the information about yourself. So in this respect, privacy is not only a right, but a societal value. And in the EU, the data protection laws have been the global standard for the past 25 years. The original data protection principles were adopted at a time when the internet was in its infancy and we had no idea the type of data processing that would be possible today. So the General Data Protection Regulation, the GDPR, was adopted by the EU Parliament in 2016 and replaces the 1995 Data Protection Directive. The GDPR has been in force across the EU since May 25th, 2018, and consequences for privacy violations and non-compliance include sanctions, legal action, and fines of up to 4% of global annual turnover. It has also inspired comprehensive privacy regulations around the world, such as the CCPA and the ePrivacy regulation, which we'll touch on towards the end of our presentation. So what are the goals of the GDPR? The primary goal of the GDPR is to give users greater control over their personal data and to unify the data protection regulations across the EU. So for individuals, this includes providing greater transparency into data collection and processing activities and providing greater control to individuals over their personal data. For businesses, the GDPR aims to clarify legal expectations and simplify and consolidate privacy regulations across the EU. It aims for improved compliance and data protection practices, including technical safeguards. So the GDPR is extremely broad-reaching and applies to most businesses that process EU personal data, whether as a processor or controller. The GDPR has limited exemptions, but typically will apply to your business if your business is based in the EU or the processing relates to EU residents. The GDPR will apply to you if the processing is related to providing goods and services, or it relates to the monitoring of the behavior of EU residents. I would recommend you consult your legal teams about how to treat GDPR in your own jurisdictions, but as you can see, it's very far-reaching and affects businesses not only in Europe, but around the world. A quick overview of the main impacts of the GDPR include an expanded scope. More businesses are regulated under the GDPR, including non-EU businesses. There are restrictions on sensitive personal data and restrictions on data transfers outside the European Economic Area. With respect to accountability and compliance, the concept of privacy by design and some data subject rights, such as the right to be forgotten, data portability, are enshrined in the GDPR. The GDPR aims to offer greater transparency to individuals and users, requiring explicit consent as a legal basis for processing. It strengthens the disclosures required in privacy policies and requires breach notification in cases of privacy breaches and incidents. There's higher risk to businesses impacted by the GDPR, including fines of up to 20 million euros or 4% of global annual turnover. So these increased enforcement powers obviously bring increased financial, litigation, and operational risk. So next in this section, I'm going to discuss some of the essential elements of the GDPR, themes that we see such as consent, transparency, control over your data subject rights, and data protection. So consent is one of the main features of the GDPR. Under the GDPR, consent must be a clear affirmative action before a company can begin collecting and using an individual's personal data. Consent must be freely given, specific, informed, and unambiguous. This means that under the GDPR, pre-check consent boxes on web forms and pages that collect information are not allowed. And the consent requirement also applies to web cookies and tracking pixels. Users should be allowed to easily opt out, withdraw their consent, or update their privacy preferences. By this means that users shouldn't have to visit more than one page to opt out. They shouldn't have to log in and verify their identity or provide a ton of additional personal information to opt out. And it should be free of charge and processed in a timely manner. So consent is the main legal basis for processing personal data. There are various other legal bases, such as contract, legal obligation, vital and public interest, and legitimate interest. Legitimate interest is the most flexible of the lawful basis. So the processing is necessary for your company's legitimate interests or the interests of a third party, unless there is a good reason to protect the individual's data, or if it infringes on individual rights. Next, we'll talk about transparency. So one of GDPR's main goals is to offer greater transparency to individuals over how businesses are using their personal data. Under the GDPR, businesses are required to disclose what personal data they collect, the purposes for collection, how they use that data, whom it is shared with, and the rights of the data subjects over their own data. So the privacy notice should be easily accessible, concise and transparent, written in clear and simple language, delivered in a timely manner and provided free of charge, and included as a link in other online forms or opt-in areas require opt-in consent. There are additional requirements for disclosure when collecting data from third-party sources, and individuals can also submit data subject access requests, or SARs, which allows them to access their personal data and how the organization is using their data. Next, we'll speak briefly to the aspect of control, or the data subject rights control over their personal data. There are 8 data subject rights enshrined in the GDPR, and I'll just speak to each of them briefly. The right to be informed is a key transparency requirement, and under this right, you must provide individuals with information about your purposes for processing, the retention period, who the information will be shared with, and your organization's privacy practices. So this information must be provided at the time you collect personal data from the individual. The right to access grants individuals the right to access their data, and this is commonly known as a subject access request. So individuals can make requests to access their data in verbally or in writing, and businesses are often obliged to provide that data to individuals in an easily accessible format. The right to rectification allows individuals to have inaccurate personal data about themselves rectified or completed if it's incomplete. And the right to erasure, also known as the right to be forgotten, allows individuals to have personal data erased about themselves. Next is the right to restrict processing, and this is a unique data subject right to the GDPR, where individuals have the right to request restriction or suppression of their personal data. The right to data portability ties into the right to access, which allows individuals to obtain and reuse their personal data for their own purposes across different service providers, vendors, or IT systems. So this might include being able to download a record of the data a company has about you, and being able to transfer this to another service, so you can continue using a different vendor for your services. The right to opt out gives individuals the right to object to processing under certain conditions, and the right to withdraw their consent. In some cases, you don't have to restrict processing if you have a compelling reason for doing so, but you must tell the individuals about their data subject rights and about their right to object to processing. And finally, the GDPR has a provision for the right to object to automated decision-making or profiling. This includes decisions made without human intervention or purely through automated means. This gives individuals the right to opt out of any decisions made in that regard. And the final element of GDPR that we'll talk about today is privacy by design, or data protection. So Privacy by design is enshrined in the GDPR under Article 25 and requires appropriate technical and organizational measures for ensuring that personal data is protected by default. This includes including data protection measures in the design phase of your processing activities, IT controls, and business practices, ensuring that data protection and privacy considerations are designed into data sources and IT systems from the outset. Also a part of data protection, there are restrictions within the GDPR for data transfers outside the EEA or the European Economic Area. So the GDPR restricts transfers outside of Europe unless there's similar and equal protections in place for that data transfer. So there's a number of ways organizations can make restricted data transfers outside the EEA, which we'll touch on briefly, and this includes adequacy decisions, if the transfer is covered by appropriate safeguards, or standard data protection clauses. In the next section of this webinar, we'll talk about the key steps towards GDPR compliance. Of course, there's many elements of GDPR compliance, but there's some trends and key steps we can take to ensure your data is mapped, your governance model is there, and that you consider privacy in the design of your operations. So first is to update your privacy policies and notices. So your privacy policies, both internal and public facing, should be documented and shared across business lines. This helps make sure that personal data can only be accessed with the proper rights based on the nature of processing and the usage of context. To achieve this, rules and definitions and access controls should be defined based on the types of personal data and the level of sensitivity. So having this privacy governance model will help link business requirements to your data sources, which will be valuable in the next steps towards compliance, such as data mapping exercises and governing your data across the life cycle. The next step towards compliance is mapping your data, understanding your data flows, and deleting any legacy data. So it's often said that the best way to protect your data is to delete it if it's not needed. So inspect, map, and identify what personal data can be found in each of your data sources and systems. So often personal data is in semi-structured or unstructured fields. So there's some challenges here to extract, categorize, and catalog all the personal data elements that your organization has. This can be a manual process or assisted with tools and other privacy enhancing technologies. So as you map and classify your personal data, you should account for the varying levels of data quality, patterns, rules, and standardization for your data, which will be essential to compliance. So understanding your data in all IT systems and devices, including mobile devices, public, private, and cloud environments. So understanding where your data is stored and how it is used will be really helpful towards governing and monitoring your data afterwards. Next is to determine clear purposes for processing and to gain additional consent if required. It's really helpful to use a consent management system in this case, and using that data mapping exercise in the previous step to help understand what data you have and what data you need additional consent for. Next is to make it easy or make it easier for users to exercise their data subject rights, rights such as being able to opt out, access, delete, or transfer their data. So here we want to consider user accessibility and UX design. as well as the channels for receiving subject requests. We suggest assigning a dedicated privacy resource or a data protection officer, which we'll touch on in the next step, to ensure that there are channels for receiving requests and to ensure that requests are processed in a timely manner. In the GDPR, it defines the role of the data protection officer, who is responsible for privacy matters, regulatory reporting, and advising on data privacy matters at an organization. Typically, larger organizations we've seen have started to assign their DPOs. And finally, is privacy by design, where we build privacy in from the start. So once you have your data mapping and your personal data inventory and your governance model established, it's time to set the correct level of data protection and safeguards for your data. So for GDPR compliance, thinking about requirements such as encryption, pseudonymization, and anonymization to help ensure that privacy is built into your systems and your projects from the beginning. So is GDPR compliance working? What has enforcement looked like, and what is the current state of compliance with GDPR? So briefly, I'll first talk about the enforcement and penalties associated with the GDPR. So administrative fines can be directly issued by data protection authorities or DPAs across the various EU member states in cases of non-compliance. These fines can total up to 20 million euros or 4% of global annual turnover, whichever is higher. The penalties also depend on the nature, gravity, and duration of the infringement. DPAs, data protection authorities, also have vast investigatory and corrective powers. They can issue warnings, sanctions, orders to communicate a data breach, or conduct data protection audits. Under the GDPR, data subjects also have the right to seek damages for privacy violations, whether they be material or non-material. So these may seem like some harsh penalties and regulatory scope under the GDPR, but is it really working? So since May 2018, EU regulators have been fined a total of $126 million for over 160,000 self-reported breaches under the GDPR. Keep in mind that these breaches are self-reported, and likely the number of personal data breaches in reality far exceeds that. So in Europe, DPAs, or data protection authorities, operate independently. Their funding, scope, types of investigations, and types of fines issued will vary across EU member states. But now that a year and a half has passed since the GDPR has come into effect, we can expect to see more guidance and fines issued under the GDPR. In the first year and a half of the GDPR, we've really seen an influx of data subject requests, breach reports, and privacy complaints. So a huge influx of that. DPAs have been spending their time processing and determining trends from these initial requests and complaints, and we can see more consistent guidance in the future. So although the fines may seem minimal so far, the operational and financial impacts of the GDPR are largely felt by small and medium-sized businesses. And although progress towards compliance may seem slow, the GDPR has in fact set a really high bar for data privacy standards around the world. It's brought privacy issues to the forefront and has inspired other comprehensive data protection regulations around the world. So we'll quickly look through two examples of fines issued under the GDPR. So first would be the Google fine issued by French data protection authorities regarding Google's confusing privacy terms. So violations included needlessly obscuring information concerning the processing of its users' data. So in this case, the users Google did obtain user consent for data processing, but hid its privacy practices behind long and confusing privacy terms. Another fine issued under the GDPR would be the record-breaking intent to issue fine for British Airways, who exposed the personal data of over 500,000 users. In this breach, login details, credit card information, travel bookings, names and addresses were all compromised. And although the fine is record-breaking under the UK Data Protection Authority, it's only 1.5% of British Airways' total revenues it was for 2018, that number should say 2018, which is far below the 4% limit set by the GDPR. So we'll take a look at the global privacy trends, including the CCPA, the California Consumer Privacy Act, and the EU ePrivacy regulation. So the CCPA, the California Consumer Privacy Act, was the first major consumer privacy law enacted at the US state level. It has been effective since January 1st, 2020, and its purpose is to enhance the consumer privacy rights and privacy notice requirements for residents in the state of California. Some may refer to it as GDPR Lite. As among privacy professionals, it's generally understood that the protections are not as strong as GDPR, but there's definitely some similarities, and you can see some of the elements of the GDPR have also been baked into the CCPA. So the scope of the the scope of the CCPA covers the consumer and household data of California residents, and businesses are in scope for the CCPA if revenues are greater than 25 million, the business processes more than 50,000 personal information records of Californians, or earns more than half of its revenues from activities selling personal information. Some similarities of the CCPA to the GDPR include increased transparency and privacy disclosures, strengthening privacy notices and privacy policies. They have a very similar definition of personal data, which is an EU term, and personal information, which is a North American term. And the definitions both relate to information about an identifiable individual or information that can be reasonably linked to an identifiable individual. Both the GDPR and the CCPA strengthen consumer privacy rights, although there are a few privacy rights under the GDPR that aren't baked into the CCPA, such as the right to rectification and correcting your data, and the right to object to processing and automated decision making. Both legislations also require that businesses maintain reasonably appropriate security measures, and onto some differences. Some differences between the CCPA and the GDPR include that opt-in consent is not required under the CCPA. The CCPA requires notice to consumers when their personal information is being collected or used, but opt-in consent is not specifically required except for the processing of children's data. The right to opt out of sale of personal information is also a unique element to the CCPA. Although opt-in consent is not required, consumers must have the right to opt out of sale of their information. And there's some other elements, such as including a link to opt out of sale on your website. the GDPR offers additional consumer privacy rights, as mentioned previously, and the penalties for non-compliance with the CCPA include a penalty of up to $7,500 per violation, and the California Attorney General can also bring civil action. So now that the CCPA has been relatively new, we can expect to see guidance and action from the Attorney General as it begins to be enforced. Next, we'll touch upon the upcoming EU ePrivacy regulation. The EU ePrivacy regulation repeals the 2002 ePrivacy directive, and it's a proposal to increase regulation over all electronic communication within the EU in order to increase individual privacy. So this is often referred to as the EU digital single market. So the scope of the ePrivacy regulation is beyond that of just personal data under the GDPR. It will include all electronic communications such as Skype, WhatsApp, Facebook messages, and any information stored on the terminal equipment of users. So this includes cookies, tracking pixels, and unsolicited phone calls. Originally, the ePrivacy regulation was supposed to come into effect same time as the GDPR and provide more guidance over electronic communications, marketing communications, and web cookies. However, it's been delayed as EU member states cannot agree on several key definitions and terms, and it's expected to be adopted in 2020, but formal enforcement is likely to be years away. Penalties for non-compliance under the ePrivacy regulation, similar to GDPR, is up to 4% of global annual turnover. I think, well, thank you for joining the webinar. Those are all the slides I have for today. I hope you've been informed well on some of the data privacy practices and GDPR requirements. Eleanor will take some questions.
Thank you so much, Judy, for a very comprehensive discussion on the GDPR. At this point, we would like to open it up to questions. I received some questions via chat. So here's a question about someone on about putting up a website. Does it have to be GDPR compliant? Let's say they're, the website owner is not catering to an EU citizen, but there may be chances that someone would visit their website from the EU. Could you provide some guidance on how they should decide on the scope? And certainly this isn't legal advice, so just wanted to remind everybody again, but we can have Judy weigh in based on her
absolutely.
expertise.
I think this is probably one of the biggest issues faced by businesses outside the EU that don't specifically target EU citizens. Really, this is a question of risk and legal risk, so I do suggest you seek legal advice based on your circumstances and jurisdiction. But there are some strategies for geofencing in the requirements under the GDPR. For example, you could create a separate landing page based on geolocation to have separate requirements for your website for visitors from the EU, or just take proactive measures to implement the correct privacy policies and cookie consents. We're seeing these requirements pop up all over the world with the CCPA, strengthened privacy regulations in Canada. So leveraging these tools for GDPR compliance, such as mapping your data, such as collecting the appropriate cookie consents, that certainly doesn't hurt. But in terms of individual risk to your business, I think that's a business decision.
Thank you for that, Judy. We have another question from the audience. How does an automation, like an automated tool, for example, SD Elements, help businesses comply with the GDPR? Can you elaborate on the controls it has?
All right, thanks, Eleanor. Our SD Elements tool is a secure coding tool, and our researchers have built-in controls and secure development requirements, guiding developers on the steps it takes to implement some of the data protection practices required under the GDPR, such as obtaining cookie consents, understanding your data flows, and the requirements for data privacy notices. So it's really a tool that helps with the step privacy by design element of the GDPR, and will help developers really understand what controls are required when building privacy into the start of your applications.
Thank you for that, Judy. And another question is, so I think you've kind of covered this. You mentioned that, with the first question, that's one of the challenges for large enterprises. What else have been, in your view, have been the most challenging aspect of implementing and complying with the GDPR for larger enterprises?
I think the challenges for complying with the GDPR are largely on the back end and with your data sources and technology infrastructure. Obviously, after updating your privacy policies and practices, the heavy lifting is really in mapping your data, understanding your data, and when personal data often lies in unstructured sources, this can be a fairly manual exercise. And getting this step right takes a lot of effort, takes dedicated privacy resources, and really just the business prioritizing privacy and the risks behind it from the top.
Great. Okay, so we'll take one more. I'm pretty happy with the audience engagement. Thank you for sending in your questions. So one more question that we'll take. What would you say are the factors that affect the penalties for non-compliance?
So this is a tough question because each EU member state, so each regulatory authority has their own scope, has their own guidance, has their own funding and resources. But generally speaking, it's persistent violations, the risk of harm, and I guess, and like, how do I say it? Like Google's and Facebook's, there's recognition, I guess. But however, even though the violations by these tech giants might be in the forefront of everyone's minds, issuing these multi-million-dollar fines don't seem to affect them as much as it affects some smaller organizations.
Okay, great. Thank you so much again, Judy, for a great session, and thank you to everybody for participating and sending in your questions. Again, we will provide a link to the recording of this webinar to everyone via email. Do join us in our webinar next month for another expert discussion on the California Consumer Privacy Act, or the CCPA. If you enjoyed the in-depth look at the GDPR today, I'm sure you will enjoy the discussion on the CCPA with our expert, Judy Zhu. Please visit the resources page on our website at securitycompass.com to sign up. Thanks everyone for attending this webinar, and have a great day.